appreciate all of you, love all of you. Like, we put together this webinar about a week of notice. I think I promote it twice, and we have like over 300 registrants. Pretty cool. And we've got 167 currently, 169, 170 people showing up to rock and roll with us. So it's fantastic to have you guys all with us. As we wait for a couple more people to come in, I'm just gonna let people kind of come in. You know what I'm gonna plug? You guys know what I'm gonna plug. Oh my goodness, where's my sticker? Where's my sticker? I'm missing my sticker. Here it is. I'm gonna plug this. That's the Law Conference of Champions. 2 weeks from today, and today is the last day to get your tickets for before like the prices go up even higher than they already are. And I'm not going to talk about the show anymore because I have promoted the heck out of it, and you all know about it. And if there's anybody out there that doesn't know about it, well, that's weird. Go to lawconferenceofchampions.com. But I'm done talking about it because I feel like I've done nothing but talk about it. And so now if people just decide they're not coming, that's on them. I've done my job, and sometimes I always hear, what? I didn't know about the show. Not this time. I've been talking about this for 5 months, right? So if somebody doesn't show up, that's because you chose not to show up. I'm not going to take responsibility for that. But everyone, thank you. Speaking of showing up, thank you so much. We have now over 200 people currently watching us live. Thanks for being here. We're going to be talking about a huge change at the state level. We are not going to be talking about McKesson today. If you want my views on McKesson, you're going to have to show up at LCOC. That's the first place I'm going to talk about it. So that's 2 weeks from today. On stage, I'll talk about McKesson. Instead, today we're going to talk about Texas. You guys know we're lawyers, but nothing we tell you right now is going to be legal advice. You can reach out to us and retain us. We'll give you lots of good legal advice. This is going to be a high-level discussion, okay? None of this is legal advice, but it is incredibly important, and I'm glad you folks have joined. Look, we know that the TCPA right now is out of control. There are twice as many to date, twice as many TCPA class actions being filed this year than last year, right? It's gone parabolic, hockey stick, whatever you want to call it. So TCPA risk is absolutely exploding. At the state level, things had kind of calmed down because Florida, of course, had the FTSA, and that was like really driving a ton of litigation. Then they amended their FTSA, and that kind of calmed things down. California SIPA was kind of really out of control. There is still some SIPA litigation, but that's starting to calm down. So people were kind of thinking, right, this massive explosion of cases at the federal level, maybe that's where we should be focused and not too worried about the states. Well, Texas had just a different mindset. So we're going to dive into that today. Before we do that, let's introduce ourselves. Of course, I'm Eric Troutman, the czar of the TCPA. You all know me. Who else do we have? Let's start with the lady in the glasses.
That would be me. My name is Queenie, better known as Puja, or maybe I got that reversed. Puja, better known as Queenie. I'm TCPA World partner here at Troutman. Amin. Happy to be here. Good to see everyone.
And Angelika?
Sorry. My name's Angelika Munger. I'm a paralegal here at Troutman Amin, and I also live and breathe the state laws. So.
As I live and breathe. Yeah, so Angelika, the Duchess, as she is known, our crack, wonderful paralegal, who, by the way, will also be hostessing MC at LCOC because she's transcendent and everyone loves her. So I'm very excited for that. She is our wonk at the state level. She's got like charts and graphs, and if you go to her house, she's got the proverbial cork boards with the pins and the yarn going from one to the other. She got this thing all figured out. And she was actually the one that alerted us initially. And as you guys know, like we're the first law firm that jumped on this. Nobody else was even talking about this, but we picked it up immediately that the magical Friday that McKesson came out. I know everyone calls it McLaughlin, by the way. I call it McKesson. I'm not going to budge on that. So the big Supreme Court case comes out the same day. Angelika alerts us, hey, this governor in Texas has signed this bill into law, which is just incredible. So let's start going through it. Puja, Angelika, break it down. What do we got?
All right, guys. Well, let's first start with the deadline. This new law that we're going to talk about takes effect September 1st, 2025. So that's going to creep up on us very, very soon. On a high level, we'll do a deeper dive into each one of these elements. But number one, the new law, the new Texas bill now gives folks a new private right of action. Under the Deceptive Trade and Practices Act, the DTPA. Which dubs it an automatic violation of the DTPA if you violate the Texas law. Previously, as some folks may be aware, there was already a private right of action under the Texas's DNC and dialer rules. However, you had to jump through procedural hurdles before you could file a private lawsuit under the Texas law. So now you get an automatic right, and with that automatic right comes $5,000, up to $5,000 a violation. So huge
5,000?
for under DPA, yes, I think it's capped at 5,000 on that one, per violation, including the registration also has 5,000. So we'll get to that in a bit as well. So
All right, let's just pause here. Let's just pause at DTPA for a second, because there's a whole bunch more, but I just want to like pause there to make sure people understand. So this is similar to in California. In California, we have what's called the California Business and Professions Code that has this provision that says thou shalt not engage in unfair, unlawful, or deceptive practices, right? And in California, there's a whole other set of bodies of law that have various rules and requirements that don't have private rights of action. But if you violate those, then you can be sued under the California Business and Profession Code banning unlawful conduct because you have engaged in unlawful conduct. So this is the same thing now that's happening in Texas. Previously, there was a few code provisions that existed in the Texas telemarketing law that everyone just kind of was like, no, it's there, but there's no way to enforce it. So do we care? Not super much. You should, but people aren't like super worried about it. But now, to Puja's point, the DTPA just kicked in, and now if you violate those laws, anything, we're going to talk about what these are now, anything in there, boom, now you can be sued in a private right of action. Now, is a class action enabled, or is this like an individual sort of enterprise at $5,000 a pop?
Just at the individual level. I didn't read anything about class action, but I also didn't read anything about prohibiting class actions.
Okay, so interesting question. I think we should assume, because like for instance in California, there's what's called a representative action that's going to be available, and they have like more limited remedies, like disgorgement, for instance. But I suspect under the Texas law, and that's something we're going to have to dive in deeper. See, we get together, we find a new issue, like almost immediately at the beginning of a webinar. I think that we can assume, and if you guys have insight on it, we have 240 people watching. That's pretty cool. And if anyone has insight, you want to put this in the chat or whatever, if you have views on this, I'm pretty sure that under the Texas law that you can have a mass or representative action similar to what happens in California. So you're not just looking at $5,000, right, for that individual. But even if you are, that's pretty bad, right? Like $5,000 a pop automatically, but you could also have potentially these representative or mass actions. All right, Puja, keep going. So just want everyone to understand that first change is stuff that you couldn't sue for before, now you can sue for. That's a big deal.
And Eric said $5,000 a pop, right? What does that mean? What is that pop, right? So now Texas has expanded the definition of that pop, or if you will, the definition of a telephone call or a telephone solicitation. As many of you TCPA followers, dwellers know that recently there was 2 cases that said that MMS, right, those video text messages that you're sending out can be subject to the TCPA. Well, guess what? Under Texas, they have now included, it brings in text messages, MMS, or any other visual solicitations within the scope of the Texas law. So, no more arguing that texts aren't calls under the Texas statute. Don't even try to argue that if you're sending MMS or video text messages that that's not a telephone solicitation. Don't bother with those motion to dismisses at the pleading stage, because the law now clearly states what the definition of a telephone call or a solicitation is, and that includes both text messages and any other video type solicitations that you are sending out to consumers.
And let me pause you again, because a lot of you might be thinking, well, I don't get it, right? I mean, texts are calls under the TCPA, so why is this a change? Well, I'm going to tell you why it's a change, because Troutman Amin, awesome legal powerhouse that we are, had convinced, by the way, properly, a couple of courts down in Texas that, hey, look, the language of the Texas Act is different than the language of the TCPA. And you ought not graft in the assumption that text messages constitute calls under the Texas Act. And we have actually won that issue for our clients and actually gotten them out of cases involving SMS messages in Texas because the Texas language did not cover text messages. That was the finding in a couple of courts. So it's always funny. We're going to hear another example of this here in a second, where like success that Troutman Amin delivers, sometimes, I'm not going to say it backfires because it helps our clients, right? We win, yay, we won. but sometimes it will result in the legislature saying, you know what, I don't like that result. We're going to change it. And that is what happened here, right? The Texas state legislature, some of these staffers might be following TCPA world. I don't know. They figured out, frankly, pretty quickly, because this is only just like the last 18 months that this case law has been developed, that, hey, look, there's a gap here. We, the lawmakers in Texas, from a policy perspective, believe that we should have protection for SMS against SMS messages that we don't ask for marketing purposes, and we want to expand the scope of the statute. So they responded, frankly, very quickly to some of the case law victories that we're talking about here. And now, starting September 1, that whole body of case law that we've been developing out the window, because now SMS messages are going to be covered by the rules again.
And, Eric, I don't think it's necessarily a bad thing, right? The way you framed it a little bit made it seem like, we pushed the legislators to confirm this new rule, but I think it actually will help folks who are caught up in litigation to not waste time and resources filing, what the courts are essentially going to think aren't valid motions on the onset. And so now you can kind of build your business practices with more clear guidance that if you're doing text message, then you're going to need the proper level of consent, especially in Texas. So I see it as good news.
All right, what else we got?
Okay, next up, I think this one was probably largely driven by, as many of you folks know, there's a ton of serial filings in Texas, right? Serial plaintiffs, plaintiff shops, they love Texas, mainly because of the registration requirement. A lot of folks want to get that 5,000 easy mark, right? They're not registered, let's sue them. But now the new law clarifies that multiple legal recoveries are permitted for the same violation, and it will not limit your future recovery. So, with this, I expect even more serial plaintiffs and plaintiff shops to want to continue to file because they kind of got the blessing from the courts. I, would probably avoid bringing up those arguments in courts now that, this gentleman has filed several cases, Your Honor, etc., because now the law clarifies those are permitted.
Puja, let me drill down on that, because as I read that provision, I read it as a single act or phone call could violate multiple provisions in the statute authorizing multiple recoveries, as opposed to a single individual bringing multiple cases against different entities.
Interesting. I read
so,
it.
And the reason I read it that way is, again, not to take credit, but if you go back in time, there was a case called Masters versus Wells Fargo. And it's ironic that it was called Masters. That was the name of the plaintiff, but there were truly masters involved here, because you had Eric Troutman for the defense for Wells Fargo. And you know who was representing Masters in that case? None other than Greenwald. So you had the great monster Greenwald versus the great defender of Eric Troutman fighting each other off in Texas. And that was actually a case where we actually won on a Rule 68 pickoff move, which is unbelievable. In addition to that pickoff move, there was a secondary finding, which is that the court determined that you could only recover once. And in that case, it was under either the federal TCPA or the state telemarketing rule, right? Can you imagine that? Can you imagine that? A court holding that you can only get one? That was Eric Troutman's doing, right? And obviously Greenwald just lost his mind, because like, this is the guy that never loses. And I just not only beat him on like a really rarefied issue, but like on something very nuanced and that you just don't see very often. So he lost his mind. But the bottom line is that case law was out there, and other courts had so held, especially in the context of multiple violations of a Texas statute, right? They kind of grafted the federal state dichotomy, and they put it into a state dichotomy, which is good. I mean, that is the proper, in my opinion, growth and expansion of the case law, right? This is a good thing. But I read the new amendment to basically say, no, Troutman, knock it off. First of all, we're going to take away your SMS win, and now we're going to take away your thou shalt not recover twice for the same bad act win. So I think, Puja, again, you might be right, I might be wrong, but I think the way I read it essentially opens the door to a single case. One phone call might violate the registration rules, it might violate the SMS rules, it might violate the TCPA, it might violate the TPA, right? So that you might have $25,000 per call, right? Depending on if you manage to check all the boxes all at once. So that is just something to keep in mind, right? Is this like enhanced punitive provisions where you've got multiple violations, I think. But you're not wrong that Texas is also a hotbed for these repeat litigators, the Colliers and Soleils of the world. So, it definitely does seem to be opening the door to their antics as well.
Yeah, and then don't forget, there's now attorney's fees also. So plaintiffs on top of, that 20 grand or up to, you can also cover attorney's fees, so.
Tell me
under-
about that. That's news. Break that
Yeah,
down.
so that's gonna be under the DTPA, which is gonna allow you to recover attorney's fees, which was not there previously. So,
All right. So before, none of this was available. Today, attorney's fees. Can we just, maybe we should have led with that, right? Attorney's fees are now recoverable for telemarketing slash, robocall slash outbound call violations in Texas. I mean, you can just kind of like stop right there because that is going to drive so much litigation. So much litigation. If they've got you for $1, they've got you for $1 plus all their attorney's fees, right? This is a completely different animal. How you litigate a case where there's an entitlement to attorney's fees is entirely different than the way you litigate a case where there is no entitlement to attorney's fees. Your tactics have to change, your strategy has to change. That's remarkable. That is a remarkable change. So again, you're talking about 5,000 I mean, not minimum, but 5,000 as your cap, right, for each violation under DTPA alone, plus whatever additional penalties exist under the actual triggering statute. Say it's 5,000 there, for illegal calls or failure to register, plus of course 1,500 if it's going to be a TCPA violation, plus another 1,500 if it's a DMC violation. So you can very, very quickly get to, one call costs you $20,000 plus attorney's fees, right? So again, TCPA is on everybody's mind. It's obviously a huge risk. Everybody knows that. But when you start layering in this Texas statute, which we haven't even kind of gotten to everything yet, you start layering in these penalties. This is enormous, guys. It is just crazy enormous how big this is. All right, go ahead. Sorry.
oh, so those are the big changes. Angelika, do you want to touch a little bit on what the existing laws were, particularly from the registration requirement? That's already been in place, folks. So this is just a added on hurdle with what we've been already discussing.
But hang on, but what about the auto dialer thing?
Well, the auto dialer definition didn't change, so we're going to discuss that. I just went through the high level changes, but yes, if you
Okay.
want to
Go ahead,
pivot,
Angelika.
go ahead.
Yeah, so currently, Texas does require, if you are a telemarketer and you're making solicitations in the state, that you must be registered. And with that registration, typically there's like a security deposit or a bond. However, I will say Texas does offer a lot of exemptions, right? So you're going to want to, first of all, you're going to want to go and read the requirements around the registration laws. You're going to want to see if you fit in one of those exemptions. I will say you want to be careful, make sure you read it all and you just don't stop like, I'm an insurance broker, I'm exempt. You're going to want to make sure that you really dig in and read it and make sure that that truly is, what's going to happen for you and your industry. And I will say, if you do have to get registered in Texas, if you read the regs, you see that you do fall under that. It's going to be quite a lengthy process. You are going to have to offer up a lot of information, particularly if you're a principal owner. You're going to have to divulge if you've ever been involved in any type of fraud or embezzlement or any type of kind of like character, background as far as considering you for registration. You're going to have to divulge that information. And so I feel like some people are like, want to look for the loopholes, right? Because they don't want to give up all that information, but it's super important. And especially with the current laws and now with this amendment, that you make sure that you are registered.
Yeah, let's talk about the loopholes because I feel like we navigated our clients through a bunch of these things because there are a bunch of exemptions, right? Can we give some good news to people as we kind of start breaking down the bad news? I mean, what are some of the key exemptions that people need to be keeping in mind, around registration, around these other rules?
Yeah, so I want to say that one of them is if you're a financial institution,
Very
right?
good.
You have that exemption. There is also an exemption typically if you are doing catalog sales. I don't know like necessarily that's modern day, but there does lie, you know, that exemption there as well. I mean, they do offer pretty robust, you know, selling media subscriptions, education and nonprofit organizations, certain commercial sales. You know, you might want to look in to see like what that looks like. But they do have pretty robust exemptions offerings. But you're just going to want to make sure that you definitely understand those exemptions and make sure that they do apply to you, because you probably will have the burden of proof, right? Like if you're saying I'm exempt and somehow you get caught up and they're going to want to come back to you and say, well, tell us how you're exempt. And you want to make sure you're going to be able to do that.
Yeah, I think, you know, at a high level, if you are making calls for your own enterprise, there's a pretty good number of exemptions that might apply to you. BPOs, third parties, folks that are true marketers that are making calls essentially on behalf of others, there's a lot less exemptions available for you. Okay, just at a high level. Again, I'm not giving you all legal advice, but I am telling you to think about this stuff. And I will tell you, you know, the courts aren't going to raise the exemption for you. I mean, they are applying this statute increasingly very black and white, and the registration requirement is not new, right? This has been there, right? There's nothing really new about it. We're just talking about Texas, so you better be aware of this registration rule. The courts have been applying it like pretty aggressively, and if the defendant can't establish, as Angelika just said, the burden of proof is on that defendant. If the defendant can't establish that there's an exemption, they're just ringing you up, right? At $5,000 a call. Like, I mean, you don't want to mess around with that. So you want to make sure that you are right? If you've got an exemption and you don't want to register, cool, rock and roll, right? But really be very thoughtful about that, because you don't want to swing and miss. Again, there's a lot of trolls out there bringing these cases.
And one thing I'll add, in Texas, for whatever reason, the Secretary of State does not want to be involved to decide whether you should be registered or not, right? So often, you know, you can probably go to the office or send them an email, give them a call to explain your business and see if you need to get registered. I know with a few of our clients, like we've attempted so, and they won't decide. So it's literally up to you and your attorneys to decide whether you should be registered in Texas. So you really want to look at, the statute, see what the registration requirements are for your particular enterprise. And, when in doubt, probably just get registered. If you are doing some kind of calling on behalf of an entity that should be registered, I would recommend you just go out and get registered. The directions and like the procedural requirements about being registered are pretty clear. So that is some good news.
Angelika, somebody asked, I think it's a good question. Real estate agents, are they exempt?
Real estate agents. That's a
You have to
good
look into
one.
that. Okay.
I
You
know,
don't
I
have
have to look in there.
Yeah, no, don't worry about it. Off the top of your head, because I thought that there was like an exemption where if the calls were not for like movable commercial property. But anyway, let's look. We'll save that one maybe for later in the day. Okay, so that's some good news, right? A lot of exemptions, particularly around the registration requirements, but not just those requirements, right? There's a lot of exemptions that apply to a lot of these provisions that we're talking about. So, if you find yourself getting picked on in Texas, or if you find yourself kind of wondering, hey, look, do I need to comply with these rules, and how robustly should I be deploying my compliance strategies here? You want to start in a weird way. You want to start with the exemptions, right? Like, do you exist under one of these exemptions? If so, you should still button up and be ready. Just because you're exempt doesn't mean you won't be sued. But hopefully, right, you can avoid the litigation, or you can get out of it very quickly by demonstrating an exemption that you're ready to demonstrate, right? Like, have that in your back pocket and be ready to demonstrate. But can we talk about the auto dialer issue? Because, like, to me, I feel like we've got 255 people watching live. We'll probably have 1,000 or so viewers, on the YouTube channel when this goes up. And I feel like what the people are the hungriest for is this, what I'm characterizing as a new auto dialer risk. I understand you're saying, Puja, technically the definition didn't change, but the new ability to sue for an auto dialer violation makes it essentially new to people. So we're going to have auto dialer litigation. Puja, you want to break this down?
Yeah, so just like the TCPA folks, right, you're going to have a DNC violation that's going to afford you a private right of action, and then now you're also going to have an ADAD private right of action for violation for using the dialer in Texas as it's defined without consent. So on a high level, if your equipment has capacity or is sending pre-recorded messages, you really, really want to pay attention here. So Texas defines their dialer as equipment that can store telephone numbers to be called or produce numbers to be called through the use of random or sequential number generator, and convey alone or in conjunction with other equipment a pre-recorded or synthesized voice to the number called without the use of a live operator. So that is the definition in Texas. It has that and conjunction that requires the use or the capacity to send that pre-recorded message.
Okay, so let's break this down, you guys. This is like, you guys showed up. You want the Jedi level stuff. Okay, let me give it to you. All right. So here's the TCPA. I'm sharing my screen. This is from Puja's article on TCPA World from June 23rd, called New ATDS Battleground Texas. Right, it's right here. All right. So you can follow along. You just look at the screen. Definitely worth reading this article. Really good article. All right. So here's the TCPA's definition that you guys are all so familiar with, right? 47 USC 227 sub A1. And we all know automatic telephone dialing system is defined as equipment that has the capacity, right? Capacity always screws us up, to store or produce telephone numbers to be called using a random or sequential number generator. Here it is, right here in bold. Now we know that the US Supreme Court in the Facebook case looked at this and read it narrowly. And it said, essentially, this phrase here, to store or produce telephone numbers to be called, comma, right, is a complete fragment that the entirety of which is modified by the term using, or by the phrase using a random or sequential number generator. You might remember you had Paul Clement, like the greatest living attorney, not named Eric Troutman, arguing for Facebook against Brian Garner, the guy who, along with Scalia, wrote Reading Law and like all the presumptions in terms of how you're supposed to read a statute. And the battle literally was, does this phrase using a random or sequential number generator, does it modify both storage or only production? But because this phrase to store or produce telephone numbers to be called is read together before a comma that offsets using a random or sequential number generator, the court found the ROS and G phrase modifies both verbs store and produce. And therefore, as we all know, you do not have an auto dialer at the federal level unless your system can either store numbers using a randomizer or create numbers using a randomizer. Okay, there's two ways that you can be an auto dialer at the federal level, but both require the use of a random or sequential number generator. Now, let's look at Texas. In Texas, the definition reads, to store telephone numbers to be called or produce numbers to be called through use of a random or sequential number generator. What are we missing here? We're missing a comma. And I'm going to tell you, folks, that comma being missing might make all the difference in the world. Because now, rather than to store or produce telephone numbers to be called, comma, which is the action, right? That's going to be modified. Here we have store telephone numbers to be called as a standalone fragment with an or produce numbers to be called through use of a random or sequential number generator. So one way you could read this, of course, is consistent with how the Supreme Court read TCPA and say the random or sequential number generator still modifies both store telephone numbers to be called and also modifies or produce numbers to be called. But I suspect the courts are not going to read it that way, and that they're going to read it as two separate requirements, right? That you could either have a system that stores telephone numbers to be called, period, or a system that produces numbers to be called through the use of a randomizer or sequential number generator. And now we look at the second piece, conveys alone or in conjunction with other equipment a pre-recorded or synthesized voice message. So if we read this in what we'll call the bad way, but in a way that truthfully many courts probably will read it, now your system is an auto dialer if it is equipment that's used for telephone solicitation, which we're going to have to define here in a second, or collection, right? It's not just marketing, it's collection. But notice this definition, how funny this definition is, right? Whether or not you're using an auto dialer turns on what you're using the auto dialer for. That's fascinating, right? If you're not using the auto dialer for a telephone solicitation or for collection, then you're not using an auto dialer at all. What a bizarre definition, but that's what we're looking at. But stay with me, okay? So it's equipment that is used for a specified purpose that can store telephone numbers to be called and convey alone or in conjunction with other equipment a pre-recorded or synthesized voice message to the number called without the use of a live operator. Now, basically any dialing system in America has the ability to store telephone numbers and leave a voicemail, right? So basically any telephone system in America is an auto dialer under this definition. Now, there might be some that you think, no, we don't leave voicemails. It's not possible with my system to leave a voicemail. It's only outbound dialing, right? It's only SMS. Alone or in conjunction with other equipment. You're telling me your platform, whatever it is, doesn't have the ability to integrate with something that could leave a voicemail? And again, I know this is like, it feels like the old footnote 63 from the omnibus ruling, right? We're talking about future capacity. It kind of feels like that. But when you talk about alone or in conjunction with other equipment, and you talk about capacity, because again, we're still looking at capacity here, right? But now can does speak to current capacity, right? That can, like right now, that's present tense, that can do this. Okay. So you might be able to argue, well, I can't leave a voicemail. I'd have to hit a switch. I'd have to put some code in. I don't know. But for those of you using 5.9, for those of you out there like using the regular old out of the box dialing systems that plainly can leave a voicemail, there's a very good chance that you are now an auto dialer under Texas law. All right. So we just need to wrap our heads all the way around that. Now, Puja, or Angelika, assuming for a second that a chill has gone through the hearts of our whole audience, and we love all of you. You feel that sting, you feel that chill, because the czar is always right. We're going to have a bunch of auto dialer fighting now. What are the exemptions? I mean, if we have consent, can we use our auto dialer to call people? I mean, is that allowed?
Yes. So first, let's start with the definition of what a telephone solicitation is, right? Similar to how we assess TCPA risk, you want to assess it the same way, right? Let's start with what kind of messages we're sending. If you are sending a telephone solicitation in Texas, which is defined, and I'll read this right out of the statute. Telephone solicitation means a telephone call a seller or salesperson initiates to induce a person to purchase, rent, claim, or receive an item. The term includes a telephone call a purchaser makes in response to a solicitation sent by mail or made by other means. So step one, are you going to fall within the definition of telephone solicitation? It's a pretty broad definition, right? And so, if you're sending marketing text messages under under the TCPA, or if you're already following that guidance, you're likely going to be sending a telephone solicitation for Texas purposes as well. Now, if you're sending telephone solicitations, but if you obtain consent, or for purposes similar again to the TCPA's D&C rules, if you have an EBR, you can send these telephone solicitations. I will, however, note that the EBR time period, I think, is 12 months, Angelika, in Texas. So you want to know the restrictions on how many months you have to leverage an EBR under the Texas's D&C rules as well.
So it's not like in the TCPA where you can use the system if you have express consent. In Texas, you're just not using an auto dialer unless you're making a telephone solicitation, and telephone solicitation is within it a definition that excludes calls made with consent or those with an EBR. But EBR is only 12 months?
Correct. It is more limited.
Okay. It would be nice if we had a slide to put up. Next time we'll put a slide together for you guys. Maybe the LCOC could be a slide. All right, so this makes sense to me. So this is a fairly positive development, right? Most of the folks that are listening to this were thinking we don't want to get sued for auto dialer usage. But if we have consent, and does it have to be like express written consent? Like what level of consent are we talking about to avoid a telephone solicitation claim?
They don't have a definition of consent. It is just referred to as the consumer's consent.
All right, so it's probably like a prior express invitation or permission requirement, similar to the DNC rules. But we don't know if it has to be in writing, huh? Well, that's fascinating. That's interesting. Okay. So fairly broad application of consent, EBR again, 12 months. This is helpful. This should ameliorate some of the risk. But when you're talking about $5,000 per and a fuzzy auto dialer definition, we can expect litigation. I mean, just bottom line, we can expect litigation. Okay, what else do we have to talk about out there?
Well, another added layer that was already existing before the new bill passed. Texas also has an oral disclosure requirement. So if you're using, you can't use an automated dialing device, the ADAD, right? So if you fall into that definition, if you're using it, unless you're giving that oral disclosure within the first 30 seconds of the call. So you're going to have to state the nature of the call while you're calling, right? Identify yourself, the person or the company that's making the call, and the telephone number you're using to make the call. So that is, if you're using AD, you also have to have those oral disclosures before you make those calls.
Yelka, what else do we have to think about?
Well, I will say too, kind of feeding off the oral disclosures, if you actually make a purchase, there is then going to be additional requirements that you're going to have to give that consumer if you make a sale, under while you're on the phone, you have this call and it's going to be like you're going to have to disclose the address, and there's going to be certain requirements under those actual sales of solicitation.
I'm getting real-time feedback from people via email talking about how my ATDS ADAD breakdown was simply gold. Yeah, no problem, guys. That's what I'm here for, But yeah, so as you're hearing from Angelika and Puja right now, though, there are a bunch of ticky-tack requirements, guys. This Texas body of law, this telemarketing body of law, which was dusty and kind of obsolete because there was no private right of action, guys, there's a lot in there. There's a lot in there. And so you really, and we're not going to go through everything today with every single requirement, right? Our goal today was to make sure that you understand that now there's a new private right of action. Basically, everything in there is now actionable, and make sure that you understand the big things. But the registration requirements and the new auto dialer requirements are your biggest, I think, key takeaways. But as Angelika is saying, there is a thicket of requirements, particularly if you're doing telesales as opposed to marketing. And you've got to make sure this is very similar to the FTSA. You guys remember the FTSA also had a huge telesales provision, and there was a big battle in terms of whether or not you could recover attorney's fees under the FTSA unless there was actually a transaction that resulted from a telesales as opposed to just a meager marketing violation. But I think under the Texas Act, the attorney's fees are a little bit clearer and more available, I think, is kind of the takeaway. But the bottom line is there are still a large number of these little nuanced requirements in there. And, we're going to keep pumping out content, particularly around Texas. But this is where you guys really need, lawyers on your side. And if you are making sales, if you're on the phone closing a deal in Texas, you need to call us. I mean, I don't want to be the guy that's like, hey, here's a webinar now, call us. But I mean, you need to, because we need to go through this with you. This is not something we can just splash up on a screen and explain. I mean, there's actually quite a bit of content there and quite a bit of nuance to it. So really, just like we told you earlier with registration requirements, does it apply to you? Does it not? Get yourself a lawyer. Telesales, these rules in Texas, very strong. Get yourself a lawyer, right? At a high level, we know that we can deal with the ATDS issues or ADAD issues from a process standpoint, right? We now have to make sure that we're only deploying that technology, really any outbound calls for marketing purposes or collection purposes to Texas, if we've got the right level of consent. And I guess we've been talking about marketing a lot. Let's just pause and ruminate on collection real quick, because we see, I think, a trend. And Brittany did a fantastic article, I think it was last Monday, looking at McKesson, not McLaughlin, McKesson, and its impact on the TCPA, right? The express consent rules. We all remember that for informational purposes, the commission, the FCC, had given us the rule back in 2008 and 2009 that any informational message you can call using an auto dialer or pre-recorded voice for informational purposes to a consumer who provided you their number for a reason, quote, closely related, end quote, to the purpose of the call. No further express consent was required. They didn't have to say, here's my number, you may call me using an auto dialer. It was implied, essentially, or what we call presumed express consent anytime that phone number was provided. Well, McKesson comes out, and I'm going to tell you that rule is deeply, deeply in doubt, deeply in doubt, right? The concept that you can just make an outbound call using regulated technology to a phone number because the consumer just gave you the number for any purpose, probably not going to fly, guys. I'm going to tell you, you're probably going to need truly express consent for informational calls at the under the TCPA at the federal level. But it looks to me like the rule is now the same at the state level, right? You can't just assume that because you are a debt collector and because that consumer provided their phone number on the application for the original creditor, that you're going to be able to put that phone number on an auto dialer and fire away, right? I know that that was the law at the federal level for a long time, but that looks like it's changing. And in Texas, as you heard Puja tell you, you have to have consent, right? And I don't think consent is going to be implied here, guys. I really don't. So those of you that are collectors, I know that not so many collectors tune in anymore. We deal a lot more with some of the marketers and first party servicers or creditors, and less with the collectors. But if there's any collectors listening, I mean, pay attention to this, guys. I mean, you're really going to have to be very thoughtful and think about switching over to deploying your your manual strategies. I mean, obviously, if you're skip tracing, you'd be doing that anyway. But even with the credit files that you're taking in and the phone numbers that you're ingesting straight from the creditors, you might want to be thinking about going manual. Okay, Puja, Angelika, what else?
Keep in mind that Texas is going to require you, if you're relying on the non-auto dialer use and subject to the DNC rules, you're going to have to adopt the national DNC registry. So that is written in the statute. So if you're not scrubbing against the national DNC, if you're not using auto dialer, you ought to be, similar to if you're already doing that under the TCPA.
Angelika, anything new? Anything else?
Yes, I will say that the state time restrictions are different than the federal call limits. Yeah. So it is 9 to 9 Monday through Saturday and 12 to noon on Sundays. So that
12
is
to noon?
yes, on Sundays. So you're going to want to make sure you're aware of that.
12 to noon. I don't understand that.
Oh, I'm sorry, 12 to 9.
12 to 9. Got it.
12 to 9. Sorry.
Okay, so 9 to 9 Monday through Friday, and 12 to 9
12 to 9
on Sunday, and they can sue you for that, and it's $5,000, right? If you get that wrong, that's not good. I don't like that. All right, so there's a lot of questions running around, and let's get to some of these. First, a question I think is really interesting is the attorney's fees provision. Does that go both ways, or is it only a one way in favor of the consumer?
Well, that is a great question. Let me take a look right now, because I do not know off the top of my head. But wouldn't that be fantastic if it goes both ways? I mean, you can go on to the next question, Eric, while I confirm.
Well, I want to answer that question. I want to know right now. Well, the next question, I guess, Angelika, I'll ask you, because I like to ask questions.
The action is entitled to recover.
Say that one more time.
The party bringing the action is entitled to recover costs and attorney's fees. So
that's just terrible. That's just terrible. So it's unilateral. The bad guys can get their fees if they win. You don't get your fees, defendant, if you win, and that's just awful. I hate that. I mean, I just hate that. It's like a punch in the gut for people. You go through all that work. I was just talking to somebody the other day, and it's like, they went through all this work and they spent $2 million in fees, not with us, with a different law firm, but they actually won the case, right? So on the one hand, good for them, right? Good for them. On the other hand, though, if you spend $2 million on a defense, did you really win? I don't know, right? And so that's the issue, because now in Texas, like I told you earlier, you got to have a smart strategy, because you can pay their fees, but they're not going to pay yours. All right, somebody asked about B2B calls. How are B2B calls impacted by these rules, if at all?
I believe that there are some exemptions around B2B calls, but I believe that they're a little bit nuanced as far as what that looks like.
Can
So
you
that
give me
would
go ahead.
So that's going to be under the registration requirements, right? As far as like if you're, well, I'm definitely going to have to look into that really quick. On as far as the B2B.
Sounds like we need an article on B2B.
B2B, yes.
In the Texas law. Puja, because my read was that B2B calls are covered, but maybe I'm wrong.
Well, if you're reading the definition, I would go lean on the definition of telephone solicitation, right? So to me, even if you're making a solicitation to a business, it's going to apply.
Yeah, can you reread that definition? I think it's important for people to understand the telephone solicitation definition.
Telephone solicitation means a telephone call, a seller or salesperson initiates to induce a person to purchase, rent, claim, or receive an item. The term includes a telephone call a purchaser makes in response to a solicitation sent by mail or made by other means.
Yeah, I mean, that feels like it's not limited to consumers. I mean, it feels like B2B is going to be covered, but I don't know, right? Like that's something that we'll dive in deeper for all of you beautiful people. And then the other question was around the definition of EBR. I think we hit that, but if you want to hit it again, because I know some folks were asking about that.
Yeah, so an established business a requirement under Texas means a relationship that's formed by a voluntary two-way communication between a person and a consumer, regardless of whether consideration is exchanged, pertains to a consumer good or service offered by the person and has not been terminated by either party.
Okay, so the word consumer is used there, which is interesting. Because you would think that these two would be symbiotic, right? You couldn't have it apply to B2B without an exemption for EBR because a consumer wasn't involved. That wouldn't make sense. So ironically, you might be able to backdoor a limitation into the restriction by looking at the exemption. You don't see that very often, but every once in a while you can. And again, this is why I'm a super nerd and why I'm so good, because I see stuff like that. Really fascinating though, Puja. I like that. Okay, and going back to the definition of telephone solicitation, I know we're hopping around, but this is fun, right? This is like Plinko. You guys remember that where the ball would come down? Anyway, so one of the questions, very clever question, does this apply to mail advertising? Out of the gate, you want to say no, but you saw that definition of telephone solicitation. It's a little bit of a weird definition. So, Puja, to what extent, if at all, do the new rules, including most importantly the Deceptive Trade Practices Act, $5,000 per claims, apply to mail advertising?
I don't think it does. The definition says it means a telephone call. And then the new bill, as we talked about earlier in the webinar, the term telephone call is defined to include text messages and MMS, right? So I think, especially in enacting this new bill, I think, the folks drafting it would probably have included mail advertisements since they wanted to clarify the definition of what even a telephone call was. And they've only included text messages with that. So I think we're safe to assume that mail is not included under just the Texas telemarketing statute. Now, whether it's included under the Deceptive Trades Act, that is something we would have to look into, which
I think it is.
I think
it is
included in there, correct?
Yeah, so and that's an important distinction for everyone to understand, right? The telemarketing rules probably do not cover mail. The DTPA, which is your Deceptive Trade Practices Act, that's going to cover everything. So if there's other restrictions out there on direct mail or the content of mail pieces, yes, you are now going to have those same private rights of action under DTPA, I think. Again, this feels like another wonderful fodder for some additional blogging. I'm looking forward to it. Maybe we'll talk about this at Elcock. I don't know. All right, so we got a few more questions here. Let me skim through this. Somebody asked about emails. I assume we're going to view that in the same lens as we just covered with mail, correct?
Correct.
A lot of real estate questions. People really are interested in real estate for some reason. All right, I'm just going to read a question. What about the call center agent working as contractors for companies that qualify for exemption under existing EBR? Do the contractors receive protection or are they separate because they're not employees? Usually EBR flows to the brand. Puja, what do we think? Again, do we want to dive in and see if there's a nuance here around EBR? It's an interesting question.
Let's go back to the definition, right? Formed by voluntary two-way communication between a person, which the contractor would be, and the consumer. So if the consumer has provided to the contractor that agreement in which consideration is exchanged, I think it would apply, Eric, based off of the plain reading of what EBR is.
Well, but hang on, because the EBR wouldn't go to the contractor. The contractor would be making an outbound call in reliance on an EBR that would have gone to a third party. So I'm looking out the window at the Marriott. So I'll just pick on the Marriott. Let's say I stayed at the Marriott not long ago, and they want to call me and invite me to come back and stay with them again. They hire BPO. BPO hires, Bob, the contractor that works in Pensacola, Florida. He makes the outbound call to me. I live in Texas. From the Marriott, does my EBR with the Marriott flow downhill to the BPO and to the contractor?
That the call, as long as that call is pertaining to the consumer good, right? The Marriott services, whatever Marriott was trying to sell, as long as that BPO is selling that service that you agreed to, then I think it applies.
Yeah, I think that's right too. Okay. Do, do, do. Sorry, guys, I'm just skimming through here. People want to know about LinkedIn or Facebook communications. I assume that those channels, social media, are going to be outside of this law. Everyone agree with that?
I don't know, are they going to be considered an ADAD? Probably
I don't
not.
know. Unpackage.
So they said Facebook messaging. I'm not on Facebook, but when you were reading off the dialer language, the first thing that popped into my head, Eric, was if I have an app sitting on my cell phone can store phone numbers. We all agree with that. If I have an app that can send pre-recorded messages, is my cell phone now in ADAD, similar to the Facebook? If there's some kind of back-end app that can sit on the messaging platform that's dropping voicemails into people's phone numbers, maybe. I just don't know how Facebook works. But I know that these platforms are continuously changing. And then if they have the capacity to add in an extra third-party application, maybe. I don't know. It feels like we're back in like Mark's territory with this ADAD definition.
Yeah, but I think from a telemarketing standpoint, I just don't think that these provisions are going to be applying to like social media advertising, LinkedIn post. Like when I do a LinkedIn post on my phone, I mean, I don't know. That doesn't feel like that's what this law is getting at, and the definitions just don't track to my eye. But again, there are other rules that turn on in Texas that turn on the content of messages and the content of marketing. And again, the new DTPA amendments are going to, I think, allow those actions to be sued on as well. Maybe not. Puja, I mean, what do you think? Am I going too far?
I think time will tell. I don't think at least the TCPA plaintiffs attorneys, I don't think that's where their focus is going to be. There might be other plaintiffs attorneys that are more looking at marketing and advertising generally, and they probably already filed suits against the DTPA. So perhaps they may be looking more keen onto those regulations, but for purposes of telemarketing and the TCPA world, I don't think so. I agree with you.
All right, so here's my favorite question that I've seen. I don't know who asked this question, but this is great. It's an anonymous attendee. The question is essentially, who is responsible for registration? Is it the seller? Is it the marketer? Is it somebody in between, right? Or the salesperson, right? Who can be sued for the failure to register? And I know the answer to this one, and it's not good. Puja, Angelica?
I think go ahead.
I was gonna say, I think it's just about everybody.
So the correct answer is it is everybody. And what's
Yeah.
fascinating, and it's really fascinating, to me it's really fascinating, is I have seen a case that says it's the marketer's responsibility, but the seller can be held liable vicariously for the marketer's failure. And I've seen it held that it's the seller's responsibility, but the marketer can be held vicariously liable for the seller's failure. So whether whether it's the marketer or the seller, courts apparently disagree, but what they all agree on is that everyone can be held liable one way or the other, either directly or vicariously for it. Now, the other question is, does the individual salesperson have to also be registered? I don't know the answer to that question. I tend to think not, but they do need to be working for a entity that is registered. But check me, Angelica. I mean, does Bob, the telemarketer working at Acme telemarketing shop or Acme lead gen have to be individually registered? I don't know. I don't think so.
I don't believe in Texas. However, there are other states that do have that requirement.
Yeah, I mean, like Virginia, for instance, like you have to identify yourself by name, right? Like, wild stuff like that. But I that's my read as well. Again, not legal advice. If you want our actual legal advice, legal opinion on that matter, you have to retain us to give that to you. But my 50,000 mile an hour webinar perspective is I don't think Bob, the telemarketer, has to individually register. But Acme lead gen, Acme telemarketing, and Acme sales, they all would need to be registered, and they're all going to be liable to each other and to the plaintiff for $5,000. And really, probably all of them would independently owe $5,000. So it'd be like $15,000 total that the plaintiff could recover, which is why they're so exciting. Okay, good question here. Would implementing arbitration clauses or class action waivers in customer agreements help reduce exposure under this law? Are there limits to this approach under Texas law? If we know, Puja.
Under Texas, the specific telemarketing law, no, but I would betcha that under Texas's contract law, that arbitration agreements are certainly going to help push these matters into arbitration if you have valid arbitration agreements. Great question and a great compliance tip, actually.
Absolutely. Okay, last one here. Is there any change update to the Texas telemarketing registration specifically, or is it just the increased risk of litigation? Melody, we did touch on this earlier. There's actually no change to the registration. It's just with the new requirements under the DTPA, just as an example, you could get sued directly for the failure to register for $5,000, and then under the DTPA, sued again for $5,000 for the same failure to register, right? So that obviously makes it more attractive. Just in plain terms, it's 10,000 as opposed to 5,000, so that's gonna be more attractive. But more importantly, the focus and the attention that the DTPA and the new claims and the ability to take double bites will now have for an already pretty raucous, particularly pro se litigant community there in Texas. We're going to see just a ton more litigation. All right. So we're emphasizing registration because that's already the soup du jour, right? That's already what's getting doled out steamy hot by the courts. And so we need to know that that's there, and we have to continue to comply with that and be very thoughtful about it. And that we're going to see even more of these claims, not because the registration necessarily has changed, but because everything else around it has changed. And that was already the most enticing body of law that was out there. So there you go. Those are our questions. We came in at 11:57. We got 3 minutes left. Puja, final thoughts. What do you got?
Look, Texas is just one of the states that has these crazy nuance requirements. The state statutes, as Angelika will tell you, you really have to read them, you have to comb through them, and you really have to get an attorney who knows their things and can apply it to your business operations. So, the uptick in TCPA cases, I predict that the uptick in state lawsuits will rise. So, just make sure you're compliant if you're operating in any states that have separate telemarketing regulations, which guess what? They all do. So take state compliance as critically important as TCPA.
Not Iowa. Iowa doesn't. Angelika, any final thoughts?
Remove child.
Yeah, I'm just gonna kind of add on to what Puja said. Words matter. So when you are looking at these laws, like it's very important that you understand them. You understand the definitions, you understand what you're reading, you understand the exemptions, and you understand what's required of you. So it's a tedious process, but there are people out there that can help you.
Yeah, and it's tedious, but you can't get it wrong because then you get broke. And words do matter. Words like I love you and words like lawconferenceofchampions.com. You guys should go. It's the last time I'm going to pitch it. Lawconferenceofchampions.com. Buy your tickets. We'll see you in 2 weeks. We love you all. I know we're awesome. You're awesome too and beautiful, and we'll talk soon. Bye, everyone.
Bye.